Good morning. I'd like to call the Value Adjustment Board meeting for October 11th, 2019 to order. I want to welcome everybody here this morning. We'll begin our meeting with the invocation given by Ms. Sandra Gilliard, and I will lead us in the Pledge of Allegiance. Please stand if you're able.
Let us pray. Father, we come before you this morning. First of all, saying thank you. Thank you, oh God, for allowing us to be able to lie down last night and sleep. Thank you for waking us this morning and then granting us traveling mercy, God, over the dangerous highways. Now, God, we thank you for life, health, and strength. We thank you for your very presence and for your Son, Jesus. Now, God, as we convene in this meeting, we pray for your divine guidance. We pray, oh God, that you would focus our hearts and our minds, oh God, on the matter at hand. Help us, oh God, to fulfill what is entrusted to us, to be fair and honest and open and hear, God, everything that is being said. And then, God, to make votes or adjustments wherever needed, God, but we pray for guidance that nothing will be done out of hatred or nothing will be done, God, out of gain for anyone else. But God, the focus at hand is that we make the right decision in each case. So God, guide us, bless us, and keep us is our prayer. In Jesus' name, amen.
Amen.
Please join me in the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Ms. Gilliard. Okay. Next on our our agenda is introduction of board members, and I'll start to my far left. You introduce who you are and who you represent.
My name is Todd Dixon, and I represent citizens of Putnam County.
Terry Turner, County Commission, District 3.
Bill Pickens, County Commissioner, District 1, and Chairman of the Board, and Chairman of the Value Adjustment Board.
Sandra Gilliard, a member of the Putnam County School District School Board, District 3.
Judd Neufeld, School Board.
Okay.
And I'm Jim Bedsoe, VAB attorney, private counsel.
Okay. I'd like to welcome Mr. Bledsoe. He's our new value adjustment attorney, so welcome.
Thank you.
Next on our agenda would be swear in the property appraiser staff. Honorable Tim Smith, Clerk of Court.
Thank you, Mr. Chairman. I actually have one task today, and that is to swear in anyone that's going to give testimony today. But before I do that, I would like to make sure that I introduce Sarah and Debbie. They work for the clerk's office. They'll be taking the minutes, and if you have any needs during your proceedings, they'll be the ones that can assist you with that. And Jim, we thank you for helping.
Thank you, sir.
So, if you're going to give testimony today, if you would please stand and raise your right hand. Do you and each of you solemnly swear or affirm that the information or evidence that you will provide today is true and correct to the best of your knowledge, so help you God?
I do.
Mr. Chairman.
Okay. Thank you. Okay. I'd like to turn it over to property appraiser, Mr. Tim Parker, for some announcements.
Good morning. I did need to read a couple things into the record before we begin the proceedings here. The property appraiser shall make a determination of the value of all property, whether such property is taxable, wholly or partially exempt, or subject to classification reflecting a value less than its just value as its present highest and best use, located within the county and according to its just or fair market value on the first day of January of each year, and enter the same upon the appropriate assessment roll under the heading Just Value. If the parcel qualifies for a classified use assessment, the classified use value shall be shown under the heading Classified Use Value. Section 193.011 Florida statutes contains the 8 factors that property appraisers shall consider in arriving at just valuation as required by the Florida Constitution and Section 193.461 Florida statutes, which pertains to classified use of agricultural property. The Florida Administrative Code is a compilation of the rules and regulations of state agencies that have been filed with the Department of State pursuant to the provisions of Chapter 120 Florida statutes, Sections 195.027, Paragraph 1 Florida statutes requires the Department of Revenue to prescribe rules and regulations for property appraisers who must substantially comply with these rules and regulations. Chapter 12D Florida Administrative Code pertains to the administration of the ad valorem property tax. Mass appraisal for ad valorem tax purposes is concerned with equity of values and systematically considers the just values of other property within groups for equity reasons, subject to variation in property characteristics within such groups. 4 interactive forces generally influence property value. These are legal or regulatory, physical or environmental, economic, and social forces. These 4 forces provide a useful analytical framework for data collection and analysis, highest and best use considerations, valuation applications, and quality assurance. Just value, which you'll hear today, is synonymous with market value. Okay? Rule 12D1.002, paragraph 2, Florida Administrative Code defines just value as the price at which a property, if offered for sale in the open market with a reasonable time for the seller to find a purchaser, would transfer for cash or its equivalent under prevailing market conditions between parties who have knowledge of the uses to which the property may be put, both seeking to maximize their gains and neither being in a position to take advantage of the exigencies of the other. In each of our appraisal reports, you will find a signed certification as evidence that professionally accepted appraisal practices were followed. You will find that our office complies with all the aforementioned criteria and has applied them to the properties you're hearing about today. Thank you.
Okay. Thank you, Mr. Parker. Okay, we'll move down to our first item of business, denial of exemption, petition number 2.
Good morning.
Morning.
My name is Shayna Stahl, and I represent the petitioner in this case. And based on the request, I brought 6 copies of evidence, and that leaves me with 4 additional copies. If it's all right, if I may approach, you might have to share, if that's okay. You have a binder?
We'll need one for the secretary, recording secretary.
We can share.
Okay, I'll give you mine when we're done. Okay.
We can share.
We can share it.
Okay.
You want to share what? I can go both directions. That might be on a different page.
We might be. We might stay on a different page.
I didn't believe that I would be a witness giving testimony, but I'm happy to be sworn in. I apologize. Sure. I do. So we're here today based on the statute 1961978 subsection 2, which, as all of you probably know, was a new statute last year in 2018. This is the second year that the statute has been in existence, although subsection 1 has been around for quite a while. Subsection 2 allows a 50% tax exemption on low-income affordable housing projects that contain more than 70 units to provide affordable housing and are subject to an agreement with the Florida Housing Finance Corporation recorded in the official records of the county. So neither of those are at issue. We know that this property contains more than 70 affordable units and that it's subject to the recorded agreement. The additional requirement is that the property has completed its 15th year being subject to the term of the recorded agreement. And that's the issue that we're here about, because the property appraiser is claiming that the term of the recorded agreement begins when the agreement is actually recorded. But of course, the term of the agreement is based on the restrictions that are required under the term of the agreement. And when the property is placed under those restrictions, and those restrictions provided with the tax credits, they are part of the agreement with Florida Housing. And of course, the project doesn't record this agreement immediately. The project is placed in service and subject to the restrictions prior to that. And that's defined in the agreement. So I wanted to walk through some of these issues. At tab 1, I have a copy of 1961978 that I just went over with you all. Tab 2 is a copy of the actual agreement. And just for reference, tab 3 is the assignment of the agreement to the current taxpayer. But we'll look at the agreement itself. So on page 6 of the agreement, in subsection 2, it defines that the taxpayer and Florida Housing, it's the intent that during the extended use period, this property will be subject to the restrictions therein of the agreement. So then you could turn back to the definition sections, which is on page 2 and 3. The extended use period, that's the important period here that we're looking at. The property is subject to these restrictions during the extended use period. So when is this extended use period? It says, it shall mean with respect to any building that is included in the development, the period that begins on the first day of the compliance period. So then we take a look on page 2 at the definition of compliance period. The compliance period means, with respect to any building that's included in the development, a period of 15 years, not a coincidence, beginning on the first day of the first taxable year of the credit period. So we have to look to the credit period and see what is the first day of the first taxable year of the credit period. Moving back to page 3, we have the credit period, which shall mean with respect to any building that's included in the development, credit period is a period of 10 years, and it begins with 1X, the taxable year in which the building is placed in service, and we'll go over the taxable year when the building is placed in service, or at the election of the owner, the succeeding taxable year. Sometimes they can choose to defer their credit period for a year. That didn't happen in this case, and you'll see that on the 8609 forms that we'll go over. So, basically that says it all. We have the term of the agreement is for the extended use period. The extended use period begins at the beginning of the compliance period, which begins on the first of the taxable year under the credit period, which would be January 1st of the year that the buildings went into service. That's the whole argument in the nutshell. That's the term of the agreement. But we can keep moving forward and looking at some of the other evidence that provides the same thing. So in tab 4, Florida Senate Bill Analysis and Fiscal Impact Statement, on page 5, under LIHTC compliance, it states the same thing that we're all seeing, that the compliance period for these developments, it's 15 years, and it begins with the first year of the tax credit period, just what we've already seen. At tab 5, we have the section 42 of the Internal Revenue Code, which is what the tax credits are based upon. I have a few sections highlighted here. On page 17, the extended use period, it makes clear that it begins on the first day of the compliance period on which such building is part of the qualified low-income housing. So these rules define when the first moment that the project is eligible for tax credits and in compliance with the subsequently recorded agreement. At tab 6, we have the revenue ruling, and on page 7 of that, it also discusses section 42 of the Internal Revenue Code, the term extended use period. The period begins on the first day of the compliance period, and that's the term of the agreement. Remember, Form 8609 is what Florida Housing uses to determine when a building is placed into service. For these properties, they're all under tab 7. So if you flip through them on tab 7, you'll see that every building was placed into service in the year of 2004. And so again, as we went over, the term then begins on the first day of the taxable year of 2004. And I know that that's a little bit confusing. Fortunately, at tab 8, Revenue Rule 9138, there was a question and answer. This isn't binding, but it really helps to understand what they mean. If you turn to question 2, the question was, when does the credit period for the building begin? And the answer, goes over, oh, yes.
Where are you at? I lost you.
Oh, no problem. Under tab 8, if you turn to about 4 pages in, there should be a highlighted section under question 2.
I go by it. 4 pages, 1, 2, 3.
Tab 8, 4 pages in.
This isn't highlighted.
Yeah.
And yours is highlighted.
Yeah. It's under question 2.
Correct.
I think we're missing that page.
Yeah.
Okay, we're good. We'll listen.
Okay, no problem. The question that was asked is, when does the credit period begin? And the answer is, of course, the credit period begins with the first day of the tax year in which the building is placed in service. And so the example given here was a building was placed in service on June 1st, 1987, and it says, well, then the credit period begins January 1st, 1987, not in June, whatever the date it was placed in service, not a date subsequently when an agreement is recorded. It's the first day of the first taxable year of the period. So I've also included at tab 9 the 26 CFR 1.42, which again defines the extended use period. And the extended use period includes this initial compliance period of the 15 years. That's the term in the agreement. And the last page of that is a slide from Florida Housing. And what's funny, I now wish that I had brought someone from Florida Housing who would be able to provide evidence and swear that the term of the recorded agreement, according to Florida Housing, who this agreement is with, it begins on the first day of the first taxable year of that credit period. We have, at tab 10, there were some emails from my office to the property appraiser that detail this argument, and at tab 11, there is an opinion letter that outlines the same information about what is the term of the recorded agreement and when it begins based on the recorded agreement itself. So the term of the agreement has nothing to do when the agreement was recorded and stamped. And that's actually not uncommon. If you think about a lot of agreements, think about a lease. The term of a lease isn't the day that the lease would be recorded, not even necessarily the day the lease is signed. What's in the lease determines the term of itself. And that's no different than the recorded agreement, or often statutes can be, the term of a statute could be retroactive or active later. And actually, I told you that this statute was new in 2018, so this is the second year. But last year, this issue came up in a few places, and it had been appealed at tab 12, University Cove Partners versus Crapo is the property appraiser, John Powers, tax collector, and Leon Bigalski. The motion for summary judgment there, it was the identical issue, and the court ruled in favor of the taxpayer. And that's at tab 13 is the order that grants the motion for summary judgment. And they say that the application for the 50% discount was inappropriately denied by the property appraiser. It says the term of the extended low housing agreement began on the first day of the first taxable year in which the complex at issue was placed in service. I mean, we can read through the whole thing, and it details everything that I've just gone through. But at least one circuit court, which is, as far as I know, the only one that has ruled on this issue, it agrees with the taxpayer here, that that's the term of the recorded agreement. You have to look at the agreement itself. You can't look at the date it was recorded, because in reality, the way that these projects work is they understand that they're getting their tax credits from that first day that we're talking about. There's no rush to go ahead and record an agreement here. This is happening 15 years ago. It's no coincidence that there's 15 years required under the statute, because that's the compliance period. So once the project is out of that period, after it's completed its 15 years, that's when this 50% tax exemption comes into play. And so that's the term that we're looking at. And I don't think there's any ambiguity I mean, we know there's no ambiguity in the statute, because it just says 15 years after the completed year of the recorded agreement. But that's our position. And I'd like to reserve a minute to come back after we hear from the property appraiser, if that's okay.
Okay. Any questions about it?
Is it appropriate at this time, council, to ask questions, or?
I believe so.
Okay, I have a couple.
Sure.
You may have covered it, but I missed it. What year do you contend is the first taxable year?
So the first taxable year is 2004 here, based on the 8609s under tab 7. All of the properties were there's only one property. All of the buildings were placed in service in the year 2004. And so we've seen through the agreement states that the taxable year begins January 1st of the year that the building is placed in service.
Okay, when was the recorded agreement done versus the first taxable year?
So the agreement, well, that's the issue, is that the building, the property is subject to the terms of the agreement prior to the date that the agreement is recorded. So if you're asking me what date the agreement was recorded, is that the question?
Yes.
The date the agreement was recorded, I believe, is September 2004.
Same calendar year, just later in the year.
Correct.
Thank you, Mr. Chairman. That's all I have at this time.
Any other questions? Okay. Mr. Parker?
So Debbie Harrell will present for our office, and then Lauren Levy will have a couple of follow-up things to say about this particular petition. But I believe the first taxable year for the project was not 2004. I believe it was 2005. It was the first taxable year, other than the land for 2004. The improvements didn't get taxed until 2005. Is that correct?
I don't believe that's correct, but if that's what this question comes down to, we can work out that offline, because I don't want to fight about that here without my having that information.
Sure. In our package tab, I believe it is 9, will show that the assessment for 2004 incorporated just the land.
Do you have a copy of that? Okay.
Tim, which one?
Tab 9.
Is that
2004 property record card?
Yes.
This one? Okay. Tab 9,
Mr. Chairman, may I ask another question?
Yes, sir.
the big
Do we have the information on what year the certificate of occupancy was issued on the buildings on the property?
It would have been 2004,
Why would that have been that?
because those are the dates that the building was placed in service, I believe.
I'm Debbie Harrell. I represent the Property Appraiser's Office. I'm the exemption supervisor, and here to discuss that as well as Woodland Point. And we are here defending the fact that it was recorded based on that September 2004. If you go to the bill analysis and the excerpts, which is tab 7 and 8, there are some highlighted statements in there for you, which doesn't refer to the compliance period, extended use period, or the credit period. And that's going to be page 75, if that'll help you. And that goes on through page...
That's in tab 7, you said?
I'm sorry, tab 8.
8.
8 and 7, 7 and 8. And then you'll go to, in tab 7, if you go to page 73, subsection 2, and it talks about beginning with the January 1 assessment after the 15th completed year of the term of the recorded agreement. So we're looking at that September 2004 recorded agreement. Since the bill analysis and that excerpts from the House bill did not disclose or make any statement of the compliance period, extended use period, or the credit period.
Could I ask you a question?
Yes, with the help with our attorney as well.
Sorry?
We'll also get help with my attorney, Lauren Levy,
Okay.
if it need be.
So was the building fully assessed in 2004?
No, sir.
All the
If-
buildings?
There was no building assessed. So if you go to tab 9, page 80, you'll see that it's small. You'll see on the line that says improvement value, there was no value for those buildings placed on the roll in 2004. If you go to page 81, you will then see that those values were picked up.
Well, is that because the buildings weren't in use as of January 1st in 2004?
I suspect that, yes, sir,
Okay, and then they got a CO sometime during 2004?
possibly. That I don't have with me.
Okay. Because your assessment would be based on
January 1.
January 1?
That is
right.
correct.
Okay, thank you.
January 1 of which year? Of '05?
2000, are you referring to the vacant, what the improvements were not on the roll, or? So it was as of 2001, 2004, I'm sorry, January 1 of 2004, the buildings were not assessed.
Okay.
They were not, as of January 1, 2005, they were picked up.
So they,
Meaning that somewhere in January, there was a CO to have them, according to what we're indicating, is that there was a CO that they were being occupied after January 1 of 2004, which
2004.
we picked up 2004 and picked them up in 2005.
That was gonna be my question.
Mr. Chairman.
So it actually didn't start until January 1, 2005?
That is correct.
Okay, all right.
Okay, Commissioner Turner?
So, just to make sure that I'm catching the gist of this correctly, the rub here, or the difference of opinion here between the property appraiser's office and the plaintiff is that the January 1st, 2005 being the first year that this starts, or 2004 being the first year that this starts. Is that correct? I mean,
The
that's
argument-
basically the whole case.
Yes, and that the recorded agreement based on the statute was after January 1 of 2004. So we're looking at that recording date based on the statute, that the recording date was September 2004, so the completed year would be September 2019, with the first year of assessment of this 50% discount that they've applied for would be for January 1 of 2020.
20.
So it's a year difference is what the concern is,
Excuse me. So,
at 50%.
That is correct.
So it's the contention of the property appraiser's office that that because the recorded agreement was done in 2004, that moves it into 2005 instead of back to the beginning of 2004, even though the buildings were probably brought into service during 2004, but your first agreement, the first agreement to pay the taxes, I guess, the first year that the buildings were taxed would have been 2005.
Correct.
Okay, so, and in the property appraiser's opinion, office opinion, that it doesn't count that they were brought into service in 2004, but you think it's the first taxable year instead of the first year that it was brought into service.
That is correct, because we look at January 1 as the assessment.
Okay, thank you.
You're welcome.
Any other questions? Okay.
Good.
That's it.
And then if I may, Mr. Chair, to just add kind of the legal opinion on top of that for a minute. Council's correct, this was a brand-new exemption in 2018. And that's always what makes my world a little interesting is you have a new exemption comes into effect, and you've got to read it, and you've got to decide what the legislature is telling the property appraiser to do. Property appraisers, we don't get to, Mr. Parker doesn't get to establish policy. He doesn't get to decide whether affordable housing is a good thing or a bad thing or should be encouraged or not. The legislature makes those decisions and tells us what to do. And it's not unusual that sometimes we struggle with the words of a statute to decide exactly what did the legislature tell us to do here. And so, if you're in the property appraiser's materials, I believe tab 6 is the statute. And so I want to talk about the statute. I want to talk about what else we did to try to find out what the legislature really meant. And then I want to talk about just a case or two to kind of give you what the appraiser is charged with doing here. So at tab 6, we have this statute. There in subsection 1, that was existing law. And that was provided what's known as an affordable housing tax exemption for property owned by nonprofit entities, all right? If you're a 501c3 and you build an apartment complex and you restrict the tenancy to what's termed as very low or extremely low or moderate income folks, and those all have a definition, you're entitled to an exemption. And the exemption goes on and says, and you're entitled to an exemption, and those portions of the affordable housing that property that provide housing to natural persons are exempt. And I'll come back to that. But I just wanted to point out that was existing law. And then in 2018, the legislature added what is starting in subsection 2 And basically, this is an exemption or discount from taxes, if you would, for for-profit entities, all right? Which is unusual in our property tax exemptions. Really, the only other property tax exemptions that are out there for for-profit entities deal with education, okay? And there's lots of private schools, and we understand that, and so those are available, but that's historically the only exemption available for a for-profit entity was in the educational arena. So the legislature added this in subsection 2, and the language that we're all looking at and trying to sort out is the language that says you get a 50% discount beginning with the January 1 assessment. You just stop there. We all understand what that is because property tax is based on January 1, so we understand what they're telling us there. After the 15th completed year of the term of the recorded agreement. And that's the language we're struggling with there. And maybe while I'm there, and if you had a pen, what I think council is trying to argue to you is that there should be some words added there. 15th completed year of the term of the, and then she would suggest we should add extended use period set forth in the recorded agreement. Okay? And I'll come back to that, but I just wanted to point that out, that I think what we're really talking about is the addition of some language that council would prefer to be in this statute. And of course, we're not able to do that. But if you would look at number 2 underneath that, just to show how the legislature, in my mind, is trying to tie together, the legislature says that this must, in order to receive this discount, it must be subject to an agreement with the Florida Housing Finance Corporation. That's the entity that oversees these types of affordable housing projects, recorded in the official records of the county. So we have to have an agreement with the FHFC, and then the discount terminates, you can see there a little bit, the next sentence, if the property no longer serves these types of individuals pursuant to the recorded agreement. So when I look at that, I mean, the legislature is clearly tasking us to look to the recorded agreement to find our answer. That's where our answer will be. Now, when you're trying to figure out what the legislature is actually doing, if you have some questions about it, typically you will go to the laws of Florida, which is actually the enacted bill, if you would, because sometimes the legislature will tell us some things in the title to that act as to what they were meaning. We included that in tab 7, and y'all can look at that. The sum of it is going to be that they really didn't help us out very much. The very first page there, the title that we've highlighted just says that we're going to discount property taxes for properties that offer affordable housing to specified low-income persons, and then it says providing requirements for such discounts. So it doesn't really tell us there's going to be requirements, there's going to be conditions, but it doesn't say what or why. And then tab 8, the next place you would look at is the bill analysis for the bill. And this is House Bill 7109. And just to give you a little bit of background, because part of my job, I'm supposed to lobby for the property appraisers up at the legislature. The last handful of years, the legislature has come up with what it calls a tax reduction package each year. And it kind of appears 2 or 3 weeks before the end of session, and it's a large bucket of tax reductions usually. And that's what this bill is. It was a bunch of sales tax reductions. It was a bunch of corporate tax reductions, and it included some property tax reductions. And I point that out to you because usually when you have a bill on a subject and it travels by itself, it has to go through 3 committees in the House and 3 committees in the Senate. And there's a lot of open air discussion, and sometimes you can go to that discussion all those comments are recorded, and you can get a little more help on what do they mean. Here, this measure, the particular we're talking about, just showed up in this bill 2 to 3 weeks out from the end of session, and there's not any great discussion of this exact provision. This is where the back-to-school holiday is always done, the hurricane sales tax abatements are done. They call it the tax reduction package. But there on page 1, you'll see it just says, for property tax purposes, the bill provides property tax relief for certain property used to provide affordable housing. Doesn't really give us more help there. And then on page 21, because I cut a lot of this out that doesn't involve us, we have a discussion. The staff analysis always says, here's the present situation, and here's our proposed changes under the bill. And so what we've highlighted there is just the present situation that talks about developers receive financing, must agree to enter into a land use restriction agreement that subjects the property to certain limitations. It describes what those land use restrictions are, that the LURA is recorded in the public record, and the restrictions run with the land, and depending upon the applicable federal and state program requirements, the restriction period may be as short as 10 years or as long as 50. And then it gives us in general the proposed changes, and then it just gives us the language that the discount will begin on the January 1 of the year following the 15th year of the term of the agreement on those portions that provide housing to those folks that have been identified. What is important to me, my takeaway from that, there's nothing in the bill itself, and there's nothing in the discussion about compliance periods, extended use periods, credit periods, all those terms that council told you were important. We got to start at extended use period, that leads us to compliance period, that leads us to credit period, and that gives us our starting date. The legislature didn't talk about any of that stuff here. All they talked about is the agreement that's going to be recorded. That to me tells the property appraiser, well, to administer this, you need to go look at that agreement that's been recorded. So the agreement that we have, what tab is the agreement in? What tab is the agreement in, Debbie? Tab 5. So if you please turn to tab 5. And, council's taken you all through the definitions of compliance period and extended use period and credit period, et cetera, et cetera. But our statute says we're supposed to look for the 15th completed year of the term of the recorded agreement, okay? So on page 13 of that exhibit, we get section 6, term of this agreement. And that, so we're tab 5. I'm sorry, it's page 13 of the document itself, page 41 of the materials before you. Everybody there?
Yes.
Okay. Term of the agreement. So this defines term of the agreement. And it says this agreement shall become effective upon the date the corporation, that's the Florida Housing Finance Corporation, executes this agreement and shall remain in full force and effect until the expiration of the extended use period or as otherwise provided. And I won't go through all the otherwise provided, but that's foreclosure, condemnation, various other things. And so the agreement shall become effective upon the date the corporation executes the agreement. Well, we could go to the back of that document, and the corporation executed that agreement, notarized and signed September 10th of 2004. Page 48 of your packet. So when we look at the statute, and the statute says the 15th completed year of the term of the recorded agreement, and the agreement defines term as beginning on the date the Florida Housing Finance Agency signs the agreement. That's September of 2004. 15 completed years would be September of 2019. So that means this discount's going to be available starting next year. All right, if you're just looking at what the legal system would say, the plain language of the statute, 15th completed year of the term of the agreement. And we've got a subsection that says term. It's recorded that same month. And that property appraiser said we denied it because we pointed out that the agreement was executed and recorded in 2004. We're looking to that execution date. Now, that also pretty much coincides with our taxable year idea that we don't assess things that are not substantially complete until the year after they're substantially complete. So on 1104, there were no buildings substantially complete. There was no assessment of the buildings. The first assessment is 1105, okay? 15 taxable years, if you would be 2020. So the two kind of go together a little bit in that regard. So I don't want to go too much into the case law, and I've provided it to your VAB attorney, but we did have one case, and I'm just going to talk about it, well, not too briefly, but just a little bit here. It was the Parish case. If you would go back to tab 5, which was your statute that we were looking at. Is it tab 5? Right. Okay. Remember I said there was an affordable, I'm sorry, tab 6, which is just the statutory language. And remember I said we had, for several years now, we've had an exemption for affordable housing by nonprofit entities. All right? Well, we had a case that came up, and the issue was whether we had an apartment complex that was dedicated for affordable housing. Okay? On January 1, which is the date that property appraisers do everything, maybe 40% of those units were vacant on January 1. Now, they were set aside for low-income folks. They were part of a larger complex that was providing services to low-income folks. But the legal question was, were the vacant units entitled to the exemption? Not the occupied ones, those were exempt, but the vacant ones. And the court went through our analysis, which is in property tax, that first we looked to the plain language of the statute, all right, and we call balls or strikes. But the court went on and said, well, if the statute's not entirely clear, then you must resolve that lack of clarity against giving the exemption away. Because our law in Florida is all property is taxable. Everybody should contribute to property taxes unless there's an express exemption. And so the courts time and time again have said statutes providing for an exemption from ad valorem tax are to be strictly construed, and any ambiguity is to be resolved against the taxpayer and against exemption. All right? That's the mechanism we're operating under. And so the court says we're struggling with whether a vacant unit is providing, because under tab 6, you'll see in that first section it talks about providing housing to natural persons and being set aside to provide housing for natural persons, or do you actually have to have somebody in that unit on January 1? And the court said that a vacant unit can hardly be said to be providing housing to anyone, low income or otherwise. Second, if the legislature had intended the exemption to apply to any unit that had been utilized to provide housing for low-income individuals, it certainly could have written the statute to state that those portions which provide and then it says, or add, or have provided low or very low income housing are exempt, because these units that were vacant, they had low income people in them the prior year. They were just vacant on January 1. And so the court said, well, really, what you're trying to do is add a little language to this statute, provided or have provided in the past. And we can't indulge in that presumption. And in fact, the court concludes by saying that after going through all the administrative code and understanding that these are set aside for low-income people, we are back where we started, which is that unless expressly exempted, property is taxable, and that statutes providing the exemption are to be strictly construed with any ambiguity resolved against the taxpayer and against the exemption, and therefore we are compelled to hold that the vacant unit is not entitled to an exemption. All right, now I included a couple other cases for your VAB council. They're more recent cases out of the First District Court, which control, well, we're out of the first, but we're in the fifth here. But it again is restating this principle that you have to have plain language establishing the exemption, and to the extent you have some reasonable doubt as to what it's telling you, it has to be resolved against the exemption. And then we certainly don't add language to a statute. We have to go with it as we choose. One of those more recent cases involved whether an acupuncture school was entitled to an educational exemption. The statute says, well, if you're certified by, and it listed 3 entities. One of them was the Department of Education. If you're certified by the Department of Education as a school providing certain things, you're entitled to the educational exemption. This school, the acupuncture school, was actually certified by the Commission of Independent Schools, not the department, and I may have that wrong, it was by the Commission, not the department. And the First District Court of Appeal said, well, there's a difference between commission and department, and even though the commission is under the department, it's not the department, and we would have to resolve ourselves against the exemption. Again, it's just another example that courts say we have an exemption, we have the language, we've got to read the plain language of it, and if the legislature uses a term, they mean it, and we're supposed to follow it, and then if we have some legitimate, reasonable confusion about it, we've got to resolve it against exemption. I would point out that one case that I told you about, the affordable housing, that was in 2005, and we're now 14 years later. The legislature's not gone back in and changed that statute, so the thought would be, well, maybe the appellate court got it right. Council did share with me a trial court decision out of Mr. Crapo's office that reached a conclusion that would be against what we were asserting here today. That decision has been appealed by Mr. Crapo's office. It will go up to the First District Court of Appeal. I would just note that in skimming that decision when I sat down, that all of those buildings there were completed in 2002. They were on the tax roll for the first time in 2003, and we were counting 15 years from 2003. The agreement was actually signed after 2003, but we were talking about the year after, and certainly those buildings had been on the tax roll for 15 years when they were getting that exemption. Again, you get these ideas of how federal tax law works, and you got to meld them with how Florida property tax law works and come to a conclusion. So when I went through it, I came to the conclusion that the 15th completed year of the term of the recorded agreement, I go to what's described as the term of the recorded agreement. It says it starts when the corporation, the Florida Housing Finance Corporation, signs the agreement. That's September 2004, and we're not there yet. To the extent that we were to believe, well, maybe the term of the recorded agreement means the term of the extended use period of the recorded agreement. I would have no objection with what council has described to you in that form, the 8609 and all those things. I understand that. But I just don't see that in the statute, and it's a little hard to presume that the legislature was telling us anything other than what it said was the 15th completed year of the term of the recorded agreement. We go to the section that defined term, and that's where we go. And again, if we had a reasonable disagreement as to what that means, then my advice to Mr. Parker would be, well, you know, we have to assume that that has to be resolved against giving the exemption. Maybe Mr. Crapo's appeal that was filed in August, you know, maybe this time next year we'll have a little more guidance, but they'll be entitled to the discount next year also. So that's where we, maybe a little more discussion than you cared to hear, but that's how we kind of resolved ourselves in our decision-making process. Thank you.
Okay, thank you.
And it will be a little bit more than 1 minute, but I'll try to keep it as brief as possible. And please keep your questions in mind for me in case I don't address everything that you might have picked up on that you're wondering about. First, Mr. Levy had stated that, you know, this is an exemption for a for-profit entity. And, you know, even though he said it's not up to us whether we are looking for, you know, to promote or not promote affordable housing, he still, you know, discussed that it was for for-profit entities. Well, the purpose of that is he read to you that these agreements can be anywhere from 10 to 50 years, but the reason that they're giving a 50% property exemption is because they want to create an incentive to keep and maintain these affordable properties. They don't want them to convert them back to market rate properties instead. And now that their tax credits are exhausted, they're looking to the property tax exemption to maintain them as affordable buildings. So I actually agree that we have to look at the plain language of the statute and the plain language of the recorded agreement. I disagreed that I would ask to read in any additional language. You know, we're not trying to sort out language. It is very unambiguous to say the term of the recorded agreement. There is an objective term of the recorded agreement, and it's not. There can't be two terms of the recorded agreement. There's just the term of the recorded agreement. They said what they meant, and you have to look to the recorded agreement to say, what's the term of the recorded agreement? And that's what I walked you through. The recorded agreement, the term of the recorded agreement is when the property is restricted. There were some questions about the taxable year of 2004, and I think you asked the proper question. Of course, the property tax assessment as of January 1st of 2004 did not include the buildings because those were placed in service in 2004. But that doesn't mean that the credit period or that the restrictions under the recorded agreement didn't start then, because of course they did. January 1st, 2004, that's when this property received their federal tax credits, their government tax credits, which they're only able to receive based upon being subject to this recorded agreement. That happened January 1st, 2004. All of the arguments that he made were the exact arguments that were denied by the circuit court for the 8th Judicial Circuit. If you want to follow along with some of their arguments, I know I read you the first 2 paragraphs of their order, which is at tab 13 of the binder, but the 3rd paragraph discusses the Section 6A. So all of these recorded agreements are pretty much identical. So it says Section 6A of the agreement does not establish the agreement's term. Rather, it demonstrates nothing more than the date upon which Florida Housing Finance signed the agreement. It should not be, Section 6A should not be read in isolation. The intent, and then it quotes the case, the intention of the parties must be determined from an examination of the whole contract and not from the separate phrases or paragraphs. In the motion for summary judgment, the petitioner had also cited case law that states you can't just look at the title in an agreement. That's a pretty standard Florida law. You don't, the title of a section in an agreement doesn't tell you what, doesn't have meaning necessarily. You have to look at the language in the agreement. And then it states 4, term is not defined in the agreement. That's true. Term is not a defined term in the agreement, and so you have to review the agreement in its entirety. The court there found that the agreement restricts the use of the complex for the entirety of what is referred to the agreement as the extended use period. That's the period that governs the agreement's term. The buildings were placed in service in 2002, but they elected to begin their tax credit period in January 1 of 2003. So that's, what gets a little bit confusing because their 8609s deferred their tax credit period. Remember, there was an X or a Y. We are under the X and they were under the Y. They began their tax credits the next year. So that's why their building date in service was 2002, but they started in 2003. But nevertheless, their recorded agreement began after January 1st, 2003. Didn't begin. It was signed after January 1st, 2003. So that's the identical argument. And the court here said, no, you take it back to when the tax credits began, because the recorded agreement begins when the tax credits begin. That's the whole point of the agreement. The term of the recorded agreement only means one thing. He spent a lot of time talking about the parish case. I'm not entirely sure why. It seems inopposite because there is no ambiguity here. The statute is clear. There's nothing to resolve about language of the statute because, of course, the term of the recorded agreement is what it is. Something that may or may not help with that, in the front of the binder is the Chapter 5 extended use agreement. This is an extended use agreement. That's what we're talking about. This is from the IRS, Section 42. And if you turn to the last page, page 60, it says the extended use agreement must be in effect for at least 30 years beginning on the first day of the building's 15-year compliance period. I've already told you why the first day of the building's 15-year compliance period, in this case, is January 1, 2004. So everybody's in agreement what the term of the recorded agreement is, except for the property appraisers. So I'm happy to answer questions based on what you've heard, if that can help.
Any questions?
Well, I have a question.
Mr.
Counsel,
Bedson?
I'm looking at the statute.
Yes.
It's very tiny print, so. bear with
In
me.
my binder, it's tab 1, slightly larger print.
So it says, beginning with the January 1st assessment after the 15th completed year of the term of the recorded agreement. But the word term in there is not defined. And I would say that the term of an agreement can be defined in the agreement. Any contract has a term, but it generally begins no sooner than it's executed by all the parties, right?
Not necessarily. So there are lots of agreements that can be retroactive, and this is certainly one of them. The agreement is signed and recorded, but the property is subject to those restrictions
Right.
long before it's recorded. And you see that with the IRS wouldn't be providing these tax credits.
What about the portion of the agreement that Mr. Levy read that says it begins when it's executed by the department?
Well, it doesn't say that it begins when it's executed by the department. It says, the problem with that section is the heading that says term of the agreement.
Well,
And
in
you
spite of the heading, that's what it says, though, doesn't it?
No, it says, this agreement shall become effective upon the date the corporation executes this agreement and shall remain in full force and effect until the expiration of the extended use period. So if you're under the property appraiser's reading that the agreement begins after the extended use period but remains in force and effect until the end of the extended use period, that just doesn't make sense. It has to be until the end of the extended use period, which is the 15 years. We're looking at the period of 15 years. In order for that section to resolve itself, it has to begin with the extended use period. So, and that's what it's clarified in the order from the judge in the circuit court, why Section 6A doesn't establish the agreement's term in the way that the property appraiser is reading it, because it's not defined. It's not under the definition section. Term isn't a defined term. Right. And when you look at when the restrictions are, you see that the term begins January 1st, 2004.
Okay, so you wouldn't agree that there's any ambiguity about it?
No.
Okay.
Mr. Chairman,
Mr. Turner?
so basically your contention is that the agreement was signed in September of 2004 and that backed it up until January 1st because it was in that taxable year. But I've really yet to see where that backs it up. I mean, unless I'm missing something here, it starts at the date that the agreement was signed, not in the calendar year the agreement was signed. And so if that's the case, then there were no additional taxes due until January 1st of 2005. So then, to me, that would say that that's the first day of the period, even though the period started in 2004. You didn't owe any additional taxes for this that year because you weren't assessed any additional value until January 1st, 2005. So would you help me get from where I am that the agreement started in September of 2004 and how that got backed up when you weren't assessed any additional taxes until 2005 on the buildings?
Sure, because we're talking about two different things. The property taxes on the buildings began in 2005, but that has nothing to do with the term of the recorded agreement, which is what we're talking about. So the recorded agreement, the buildings were placed in service in 2004, and the recorded agreement's term begins based on the defined terms in the agreement. It begins January 1st, 2004. That's when the tax credits began, even though the buildings weren't assessed for property value January 1st, 2004, the tax credits began for restriction of use of that property based on the recorded agreement.
But if I may, Mr. Chairman, but if the language states that it starts at the date of the signed agreement, that would put the date in September of '04. And so, unless I missed something here, that's what it says. And so there's no additional taxes due. And I understand that you're saying it's two different issues, but it's not, because if it starts in September, I don't see anything here that anybody has shown me where we can back that date up to January 1st of that year, even though they're in the same calendar taxable year. I don't see if it started at September of '04, I don't see how you can back it up instead of moving it forward to the next taxable year, because no additional taxes were due after September of '04.
Well, that's the thing, is nothing actually started in September of 2004. That date is only the date that this agreement was recorded. But the term of the agreement,
That's when it was signed.
or when it was signed, the term of the agreement has restricted the use of the property from before the date that this was signed. So again, the way that these work, because of the credit period and the date that the credit period starts, they're not in a rush to sign and record these agreements because they're already restricted under the use. They're already getting their tax credits. The signing and recording of the agreement has nothing to do with the term of the agreement and when its restrictions are placed on the property.
So could I ask another question?
Sure.
Did they get a tax credit in 2004?
Yes.
Okay.
Based on, and that's in the 8609s because they elected to receive the tax credit for that year.
And that was a tax credit on the real estate? Or,
It's the affordable housing tax credits based on this, you know, Section 42 of the Internal Revenue Code for low-income housing tax credits. It's the federal tax credit. You can get it for the 10 years for,
well, why wouldn't to Mr. Levy's point, why wouldn't the statute clarify all this for us?
I think the statute is very clear. The statute says the term of the recorded agreement.
Yeah.
And that's why I almost, if you're still unsure if there's a way to adjourn and we could come back, we could bring a representative from the Florida Housing, if that would help who could testify that they're signatories to the agreement, and they're the ones who are going to say the term of the agreement starts January 1st, 2004 in this
So
case.
let me ask you another question. Does this agreement terminate at the end of the 15th year?
This agreement does not, well, I have a few of these, but I believe this one is a 30-year agreement. Yeah, the extended use period ends on the later of the 30 years after the final tax credit allocation. So this agreement does not terminate at the end of 15 years.
And it terminates 30 years after what date?
I'm going to have to discuss with my affordable housing people because I don't want to misstate anything about when this terminates.
Because I see the basic,
The compliance period terminates 15 years after January 1, 2004.
right, and that's something that's defined in the contract?
Correct.
Right. Well, the contract isn't, I just keep going back to the statute. The statute says the term of the recorded agreement, beginning with the January 1st assessment after the 15th completed year of the term of the recorded agreement. And if the agreement wasn't effective until it was signed, you're saying it was effective before it was signed. How is that?
The term of the agreement.
No, how's the agreement effective before it's signed?
The term of the agreement,
No, how is the agreement effective before it's signed? That's what you're saying, it's effective before it was
it's
signed.
retroactively affect, the term of the agreement is
Yeah,
retroactively
but it's only
effective.
effective when it's signed, right?
I don't know the distinction that you're trying to make, but the question is, the term of the agreement begins on January 1, 2004,
Well, I
regardless
think
of if it's signed
one
in
of the
September.
distinctions is that you have focused on when the units were placed in service versus the actual term of the contract. So you're saying that the property became, if I understand you, became subject to the exemption in January 1st, 2004?
Correct.
Okay. And was it subject to the exemption or placed in service somehow before that?
It was, well, on the 8609s have the in-service dates.
Yeah.
And the recorded agreement states its own term, and that the tax credits begin on the first day of the first taxable year, which is 2004.
Yeah.
Which is when they received their tax credits. It's the 15th completed year of the term of the recorded agreement. So the term of the recorded agreement begins January 1, 2004. The last day of the 15th year is December 31st, 2018. So January 1, 2019, it's completed the 15th year. And it's then out of the 15-year compliance period. That's what I'm asking, maybe we should have bring testimony.
So you,
before
the
housing.
basic problem is that you and your client and the property appraiser define the word term differently.
I don't think
I think so.
that we could possibly, well, no, the question is, the term of the recorded agreement, there is a term of the recorded agreement. That's not ambiguous. There is an answer. There is a term. It's not subject to interpretation.
Okay. But the statute doesn't go into any of that. It just says the term of the recorded agreement.
So then we look to the recorded agreement and say, what's the term of it? And that's what the judge found in the case that we
But
looked at.
doesn't the agreement say that the term begins when it's signed by the department? Isn't that what it says?
No, the term of the agreement, they said that the judge agreed that section 6A of the agreement, which I believe
not
is what
talking
you're
about your
referring
case,
to,
I'm just
does
talking
not
about-
establish the agreement's term. You
Right.
have to look at the agreement as a whole to see what's the term of the agreement? How long is it restricting the use of this property? That's the term of the agreement.
Thank you.
Okay, Commissioner Turner?
Yes. Under tab 7 of your submittal that you gave us, your evidentiary submittal, it basically, the 8609 applications that were sent were signed in '06, and it clearly states at the bottom it was for the tax year '05. So I still fail to see how we can get back from us, and keep in mind, I'm no judge here, but I do have a little bit of common sense, and that's what I'm trying to use. And that I'm having a hard time backing it up from the signed date with all the evidence that I have heard here today, and the signed date is in September of '04. And I don't see how that makes it the tax year, because you were not receiving any tax credits for that year. Even in the 8609 application, that clearly states at the bottom, it's for the tax year 005, and that's under section 7, fellow board members, and right down at the bottom. So I can't see how that could be your first taxable year, even though I understand that you're saying, oh, well, I paid property tax that year, but the buildings weren't brought into service until '05. So I'm just really struggling on how we back it up a year, when everything I've heard here today basically says from the time the agreement was signed, it seems to me like, and not the year of the time the agreement was signed, but when the agreement was signed, it kind of starts the period. And if I'm understanding correctly, your contention is that means you were in the tax period of '04, so you should get the '04. But I don't know that, and then you gave us the low-income housing credit application and certification for an '05 year, which is the following year. So I don't see where we can say that the agreement didn't start in September of '04, and you really didn't have a taxable year that it counted in until January 1st of '05.
So the date on the 8609s to look at is the in-service date, which are all in 2004. If you look at, under tab 2, at the recorded agreement, under credit period, it means with respect to any building that's included in the development, the period of 10 years, so that's when they first began to get their tax credits, beginning with X, the taxable year in which the building is placed in service. That's 2004. Based on these 8609s, we meet tab, or subsection X, the taxable year in which the building is placed in service. It means, and that's, these agreements are a little bit confusing. The people who do affordable housing do these all the time. I'm happy to bring someone here for you to ask questions to, who has done thousands of these, hundreds of these, that will explain to you, someone from Florida Housing, who will explain to you how the term of this agreement works based on the extended use, the compliance period, and the credit period, which essentially involve the term of the agreement.
I'm just trying to understand. It was signed in September 2004, but you stated, help me understand. Did you state, even though it was signed September 2004, it was retroactive? Is that not what you're saying?
The term of the agreement. So the agreement, there's no doubt that this agreement includes a 15-year compliance period, and that 15-year compliance period began January 1st of 2004. That is really undisputed. So,
And you're saying that's what the statute refers to?
yes, the statute refers to the
Okay.
term that's in this agreement.
That's what I understand.
And so who else was aware that it was retroactive? I mean,
We're calling it retroactive because I guess essentially the term is begins before the execution of the document. So in that sense, it is retroactive. But they negotiate this with Florida Housing prior to even building these buildings. I mean, the term of the agreement is set long before this agreement is pen to paper.
I think, Mr. Chairman, if I may, I think what we're being asked today is to make a legal determination on when this starts. And I don't know that I have the ability to do that, even though I've been given that task. But I still fail to see how we get there from here. They didn't receive any benefits, any taxable benefits until the year 2005. It may have started out that it was put in service in 2004, but the agreement was the first agreement that I have evidence that was subjected was for the 2005 year, that it was actually submitted in the 2006 year. So that's the first, to me, that makes it the term of when it starts at 2005. And maybe I'm the only one here, but it seems to me like that might be where we are.
Would it be helpful to adjourn and come back to have an evidentiary hearing and bring testimony?
Well, this is testimony. You're offering testimony.
I understand.
We're having an evidentiary hearing right now.
All right, an evidentiary, would it be helpful if I could bring somebody from Florida Housing, the other party to the agreement?
I don't think so.
Okay.
It's not going to clarify things. I always go back to the plain language of the statute, which is where everything starts. And it says the term of the agreement. It's not defined, but the ordinary understanding, the basic definition of the term of an agreement is when it's signed and when it ends. And the developer is subject to all kinds of restrictions prior to signing this agreement because they're counting on that. But the agreement itself, the statute just doesn't go into parsing between the 15-year period and the term of a recorded agreement. And the agreement seems to indicate that it's not effective until the department signed it, which was in September. And that would mean that the 15 years expires September this year. So next year would be, and I think that's the property appraiser's position.
Mr. Chairman,
Okay, Mr. Dixon?
I read the statute saying that unless otherwise indicated, that this does begin on January 1st of the year that the term of the agreement is signed. I think that's in the statute. So if the agreement was signed in September of 2004, which it, although I agree with Mr. Turner, this is 2000, right here in at the statute itself.
Six of this one,
Or one on the other one.
This one.
That it does kind of indicate to me, language-wise, that it goes back to the beginning of that year, of the year that it is signed. We could determine, contractually, I think that the day something is signed is actually the day that the agreement begins, but I don't read that the same way here. It seems to indicate that the term would go back to the beginning of January 1st of the year that it's signed. So 15 years after that, January, the completion would be. I have the same question, though, about why are all these 8609s indicating the 2005 tax year? That doesn't seem to make any logical sense, that you're asking for something in 2005, and today you're arguing that it should have been 2004, and yet you have multiple 8609s, which is probably each individual building as it came online, for the 2005 year, which seems to state that you thought that it was 2005 was going to be your first year of operation, even though you say that it goes into service in January of 2004, and then in April of 2004, and March of 2004, and has several units, I'm sure, are completed and are certified for occupancy. So that's a big discrepancy. I think the statute says one thing, your documents say something else entirely.
Well, we just look at the in-service date on the 8609s.
Yeah, but I still have a problem with that why, if the in-service date is indicating 2004, why does not the tax year that you're claiming the 8609 on say 2004? Which I think was Mr. Turner's.
Well, even, if I may, Mr. Chairman,
Mr. Turner.
even with what Todd just mentioned, I mean, it says the January 1st assessment after the 15th completed year of the term of the recorded agreement. So I still am having trouble. It says the January 1st, beginning with the January 1st assessment after the 15th completed year of the term of the recorded agreement. So that, to me, says that it's the January the 1st after the recorded agreement, not before there. And so I'm still having trouble getting back to January 1st of 4 instead of January 1st of 5. I mean, I'm trying, but I really am, but I just don't, I can't get there. I mean.
No, I can't either.
I would, and the way that the documents read here, the 8609s, I don't think that they thought that either, or they would have said 2004 on their 8609 applications for this certification.
Yeah, I think, if I may, Mr. Chairman, I think that they would have went after another year's credit on the other application if they'd had it, but because it was put into service from March of that year and different dates throughout the year, I'm not so sure that they could go back there because their buildings weren't in service yet. But I still fall back on, I guess, the whole thing we're trying to interpret here is that we have the task of interpreting is what the term of this is and when this term starts. And I just can't quite get there, that it starts in January of the year they didn't get any credits for or what have you, and especially with what Todd just brought up. I mean, I have to read that as saying it's January 1st of the year
Following.
after completed term of the recorded agreement. And that after, to me, says it's January 1st after the recorded agreement. So that even more so, thank you for that, Todd, that even more so helps me say that how can you back it up when it clearly says in the statute it's after, and that's not adding any language or having any interpretation. Clearly says after the term.
It might help to re-review question and answer 2 under tab 8, the Revenue Rule 9138, if that's helpful, because it's not a question that the credit period here began January 1, 2004. If that helps with you know, how you're backing it up into, the credit period is part of the term of the recorded agreement. Credit period, even though we have an in-service date middle of the year and a signed agreement middle of the year, this explains why the credit period begins the first day of the tax year, which is placed in service.
Of the signed agreement, which was signed in September of 04, that's what you're saying?
Right, but
Okay.
look, each building has only one credit period. It's not an ambiguous when this period begins. And it begins here on January 1.
It may not be ambiguous to you, but it sure is to me. And I think that's what the whole decision here today has to be based on, is when does this term start? Because you're saying it's January 1st of 04, and property appraiser contends that it's January 1st of 05, and I can see both sides of it and why both of you would look at it like that. But I'm sorry, I'm just having a hard time getting backwards from the start date when you didn't receive any additional taxes, so you didn't have to pay back then. So your 15 years should have started as the statute clearly states that you gave me. I didn't know about this till I came in here today, beginning with the January 1st assessment after the 15th year completion of the term of the recorded agreement. So that tells me that if that's 15 years after is the end of the term, then the thing shouldn't have started until the January 1st after the 15 years started.
Well, let's take a look back to the agreement itself, setting aside 196, 1978. Are you with me that the credit period, the compliance period, the extended use period of this agreement begin January 1, 2004? Or are you having trouble with that?
I think from what I've seen so far, I think the agreement starts in September of 2004, and then because the statute clearly states in 2A, right here, clearly states, it says, beginning with January 1st assessment after the 15th completed year of the term of the recorded agreement. So I'm having a hard time backing it up. I mean,
So the recorded agreement includes defined terms, which include a credit period, the compliance period, the extended use period. The property appraiser and their counsel, I don't think would disagree that that credit period and compliance period for this property began January 1, 2004.
would you agree
that-
with that?
That's correct, right?
As those terms are defined, yes, sir, I would agree.
So you think you think the term of this agreement was January 1st, 2004?
No, sir, not at all. The compliance term, the credit term, the extended use term, all of those for the federal IRS side began January 1, 2004, but this agreement term starts September of '04.
So that's what I want to, right, oh, sorry.
If I could, for the IRS, you had to restrict this for 30 years, okay? That's for the IRS. This one, extended use term, for Florida, this is a very competitive process for this affordable housing program. And you can, it's done on points. You know, you do certain things, you get points. And people try to max out their points. And one of the things they do is they agree that we will set it aside for a period longer than the federal government requires us to do. And that's 50 years. And so you'll see at the very beginning of the agreement, it says, hey, this extended use time period, the owners made a knowing, voluntary, and intelligent election to waive for 35 additional years following the last day of the compliance period. So that's additional time to get priority within the state. Federal government only required 30 years to compete and be awarded these credits. This owner said, I'm going to do it for a longer period of time, 50 years. Everything the IRS does, the first day is 1/1/04. But the term of this agreement for that additional time is as the term says, September of 2004. And you know, if you were going to assert that the term of this agreement actually had some other date than when it was signed, I would be looking for some retroactivity. That where it says term of the agreement, this agreement shall become effective. It says upon the date the corporation executes this agreement, and its first day shall be deemed to apply retroactively to the first day of the compliance period. I mean, these things are lawyered and wordsmithed to death, and so the absence of that means to me, well, it's September of 2004 is where we're at.
You do agree that any time period in this agreement, including the credit period, compliance period, the 50 years that you're talking about, the additional 35 years, those all begin January 1st, 2004?
No, the term says it shall become effective on the date the corporation executes this agreement and remains in full force and effect until termination of the extended use period. The only tie, if you would, to the term of the extended use period is the end of the extended use period, not the beginning.
But if I may, Mr. Chairman, but the end of a period is so many years of the agreement after the beginning of the period. And the end of the agreement clearly states it's on January 1st following the signature of the agreement. Did I miss something here?
Correct. The January 1 after.
Yeah.
Yes, sir. So we're looking at September '04, which is why we think there's one more year before they get there.
Any other questions? Comments? Okay. Legal counsel, you have any other comments?
No, I think if the questions are over, you can entertain a motion for it.
Okay. All right. No more questions. The chair will entertain a motion.
Mr. Chairman, I move that the admitted evidence proves by preponderance of the evidence that the methodology used by the property appraiser to assess the property complied with the statutory requirements and professionally accepted appraised practices, and the appraisal is entitled to a presumption of correctness.
Okay, got a proper motion. Do we have a second?
Second that.
Okay, got a proper motion or a proper second? Okay, any further discussion? Okay, Judd,
Second.
Mr. Newfeld. Mr. Turner on the motion and Judd Newfeld for the second. Okay, any further discussion? Okay, all in favor, in case saying aye.
Aye.
Opposed, same sign. Okay, passes. Do we,
I think the second one is part of the first one.
what do you say?
He was asking about the second,
Oh, we had to do the second.
second form.
No.
Okay, that's good enough.
We're good.
Okay. Okay. All right, we'll move down to the next item. Request for an alternate hearing date. Has that already been taken care of, Sarah, on these or not?
I think this one is going to need to be a discussion, if I'm not mistaken, because essentially, we kind of rearranged the schedule around after speaking to Mr. Bedsole, but I do know that the property appraiser's office has something to say on it.
Okay, I believe if I understand correctly, the petition 41 and 42 were scheduled for 3 p.m. today?
That is correct.
Okay, and Mr. Bedslow, his schedule did not, he was not able to be here for 3 o'clock? Is that correct?
That's correct.
Okay, so these need to be rescheduled, but, Mr. Parker, do you have a comment?
No, we were just prepared to hear the petition, so I would suspect that it would be postponed until November. Are they good with the November date?
Yes, that's what we'll do.
Okay.
The November 15th.
41 and 42. Okay, and do we have a date in November yet?
November 15th.
15th?
Are we allowed to do that?
Change the date.
I went through your school and you told us to do all 11 modules. I didn't see anything in there about alternative hearing dates.
The board can't meet without a VAB council. Now, I can't be here.
No, I'm not saying that. I'm just saying, we're allowed to move that forward?
Oh, absolutely.
The petitioner was agreeable.
Okay, do we have to move that in a motion, or we're just rescheduling?
I don't believe so.
Yeah, you can just reschedule it.
Reschedule, okay. Okay, we'll move down to petition 49, good cause hearing for late filing, Michael Charles Leonard. Okay, can we recess for about 3 minutes?
In 27 seconds?
27 seconds. Okay.
After moving here, I came to the property.
Okay, I'll go ahead and reconvene the Value Adjustment Board meeting. And petition 49, is the petitioner here? Okay, I guess I'll ask the position of the property appraiser.
Sure.
Just for cause of hearing for late filing.
Right, so this is up to the board to determine whether or not the cause exists for a late filing of a homestead application. The petitioner meets all the criteria for having homestead exemption on their property, other than the fact that they file late. The filing deadline's March 1. And your counsel may have some instructions for you as far as what are the reasons for filing for a late file petition.
Yeah, sure. So the standard for late filing is that you can demonstrate a cause which was out of your control, basically. It has to be an extenuating circumstance. And I can't read every word of this written explanation he's got here, but it sounds like he just didn't know that he had to file an application for homestead, which does not qualify as a reason. Ignorance is not a reason. It has to be a family emergency, it has to be a medical emergency, it has to be, these days, if you allege anything about being delayed by hurricanes, that's good cause. Things like that. It has to be something out of your control. And I don't see anything alleged here that indicates that it was out of this petitioner's control. And they'll get a homestead next year.
Okay,
I mean, if they apply.
okay.
So I would recommend denying the good cause.
Okay. Any questions by the board? With the recommendation by the legal counsel, I will entertain a motion.
Mr. Chairman, I have a question for council first, if I may. Is there, so what you're saying in your opinion is we have no choice but to turn this down because there's not a valid reason they're asking for the homestead exemption?
Right. The two elements are that he has to allege enough in here to qualify for homestead exemption, and that's the first step. And property appraiser has already said he would qualify, but for the fact that he didn't apply for it. And so he hasn't made an application, but he's asking to be given an extension so that he can file, but you can't show good cause if you don't have an extenuating circumstance or some circumstance that beyond your control that caused you to be late. And I don't see anything in here that alleges anything like that.
Thanks.
So I'd say that it's, and the petitioner's not here to explain things, so I would recommend denying the good cause application.
May I ask a question, please?
Sure.
Mr. Dixon?
So, yeah, in this petition, it says that the person moved here in 2018, he's asking for the current year's exemption, which you would have had to apply for by March of this year? Is that
Sure.
correct?
So he moves here in 2018, okay, and he gets a tax bill in 2018. So it shows homestead exemption on the tax bill because the prior owner had homestead exemption.
Because it's past.
And I think what he's stating here is this, I think it says, in South Carolina, exemptions there continues year after year.
They don't have to
So
reapply.
I don't know
Right.
about South
Right.
Carolina.
Sure.
And I don't know, counsel, have you provided the panel with the excerpt from the Department of Revenue rules on the reasons for,
No, but I have the rules with me, and I could, if you'd like to.
I understand now.
He does state that he received the tax notice, but he filed it, not realizing, didn't read it, not realizing that he needed to go ahead and file.
right, the notice of proposed taxes reads on the top of it, this is not a bill, do not pay. So a lot of people don't read down very far. I mean, it's got last year's information and then it has this year's information. And then if you look at the bottom of the page, there's about $800 difference between what the taxes were last year and what the taxes are this year. So that's what barely, I guess, if you want to say in time, that he caught and came in immediately. I think it was, I think you have a copy of the application there. On October the 9th, just before this board would meet, and filed a petition. Had he come in at a, past our second VAB date of November, it would have definitely been there would have been no opportunity for the board to actually have heard it. So council will kind of go over the 4 reasons there on that page, I guess, that.
Yeah, thank you. Yeah, I'm reading the Florida Administrative Code, Chapter 12D9, .015, or, yeah, 015, paren 14. Anyway, it says late file petitions. Good cause means the verifiable showing of extraordinary circumstances as follows: personal, family, or business crisis or emergency at a critical time and for an extended period of time that would cause a reasonable person's attention to be diverted from filing, or physical or mental illness, infirmity, disability that would reasonably affect a petitioner's ability to timely file, or miscommunication with or misinformation received from the board clerk, the property appraiser, or their staff regarding the necessity of the proper filing procedure, and any other cause beyond the control of the petitioner that would prevent a reasonably prudent petitioner from timely filing. So it has to be something extraordinary, and being confused about whether or not to file is not one of the bases, which is what I gather from this.
It probably should be, though. I mean, if you're confused about whether you should file coming from another state, I'm sorry that it isn't, but it should be.
Okay, any other questions? Okay, what's the pleasure of the board?
Mr. Chair, if I may, I move that the petitioner did not appear at the hearing and did not state good cause for not appearing, and relief is denied, and this decision is being issued in order that the right of the petitioner may have to bring an action in the circuit court is not impaired.
Okay, we got a proper motion to deny by Judd Neufeld. Do we have a second?
I'll second.
Okay, we got a second by Todd Dixon. Okay, any discussion? Okay, seeing none, all in favor indicate by saying aye. Aye. Opposed, same sign. Okay, petition denied. Okay. Are the parties here for the 11 o'clock, I believe? Yes, sir. Okay, and you said we could go ahead and start, Mr. Besso? We could go ahead and start a little early? Okay. All right, we move down, petition for real property value. Petition number 9, CVS 3663, Florida LLC. Mr. Clark Mann.
Sarah, while he's walking up here, did you get one of these? Okay, that's from the last case. I put the book, I put their evidence on your desk a minute ago.
Thank you. Yes. I'm representing 2 CVS stores in Putnam County, the property tax assessments, and I have this information. I was to bring 6 copies, I believe, and pass them out accordingly.
Thank you, sir.
Sarah, I'll give you my copy when I'm done.
Unless he writes all over it.
Need to be sure and write on something else.
The first cover letter just summarizes why I'm asking for a review of the assessment. The first, I call it the interlocking CVS is valued at $1,958,986, which I believe is correctly assessed and accurately assessed. The second CVS that we'll get into, I'm talking about both of these at the same time, is the East Palatka store, which is assessed at $4,827,960, which I think is overassessed. I'm recommending an assessment of $2.5 million, and I'll get to that in a few minutes. I've provided a detailed analysis of income approach, the cost approach, comparable sales approach, and comparable assessments, just to look at the East Palatka store assessment. If you will turn several pages in the packet, I will summarize this, and it's about 5 pages back, and it starts with my on the bottom right-hand side, my handwritten page numbers, page 2. If you'll look at the first box, top box, explains the East Palatka location, the size of the building, 13,556, and the date of construction, 2010. If you move down to the middle box, it gives some detail on the 2019 assessment, and you can see the land is valued at $1,179,000. The improvements, however, are valued at $3,647,870. This is basically twice the rate that's being used for the other CVS and the Walgreens. The total assessment is $4,827,860. And one ingredient in this assessment, I think, that pretty much pushes it way too high is the property appraiser is assessing the wall at the East Palatka store, the retaining wall, for an additional $1.5 million is applied to that, which pushes this assessment up much higher. In the bottom box, I have an income approach. I've estimated the rents for the East Palatka store at $16 a square foot. I go through detail in there, looking at all the rents in Palatka that I could find. East Palatka and also Palatka on 19th and Creole in that area, which to me is a superior area than the East Palatka. And the reason I say it's superior is properties there rent for more there than they do in East Palatka. The Walgreens is at the corner of 19 and Creole. In my opinion, it's a superior property. It's very similar in size, and the Walgreens is assessed at $2,591,530. It's superior in my opinion. It is slightly larger, but they're very similar in size. Just, I believe, 500 square feet difference in building. I have a cost approach. We've used Marshall Swift Valuation Services. It creates a value of $2,720,000. That's recognized in the property appraiser's land value at over $12 a square foot, or exceeds $1.1 million for the site, which I think is appropriate, except for the wall is included in there too. I've looked at comparable sales. There's not much sales activity in Palatka, but I've looked around. I think it's my weakest approach. I've come with $200 a square foot, indicating a value of $2,711,000. Looking at the sales approach. Once again, comparable assessments I looked at as well, and I think the 3 main most comparable assessments is the other CVS store in Interlochen, which is assessed at a rate that creates a $1,900,000 assessment. I've looked at the Walgreens assessment, which I just stated was at $2,591,000. Using the Walgreens rate for the East Palatka store's size, it would indicate $2,491,900 for the East Palatka store. I'm requesting an assessment of $2,500,000. Looking at all these approaches, I think the strongest approach is the cost approach, and I believe the most fair approach is the comparable assessments. I mean, we're having to compete with Walgreens, yet they have half the tax rate that we have to compete with, the amount of tax. And like I said, the Interlaken Walgreens store, we think is properly assessed at the slightly under $2 million assessment. And that is my appeal to you, is to have the property assessed as other drugstores assessed in the county and not be penalized because it has a concrete wall that's built on the lot.
Okay. All right. Any questions? Okay. All right, thank you. Mr. Parker?
Mr. Chair, Donald Hunt will be presenting our information to you. So you may want to take some advice from council. I know the petitioner is addressing or attempting to address two petitions at one time. So the first petition that we have scheduled for you to hear is the Interlaken CVS. And then the second petition that he has petitioned is the one in East Palatka. So it's up to you and your council, however he think you should want to hear the case or the information, and we can go from there. We can address one at a time, or we can skip to the East Palatka one. Ultimately, the petitioner doesn't really have any, and I don't want to put words in his mouth, but he doesn't have any problem with our valuation on the property in Interlaken. I guess he's brought it to your attention for comparison type purposes. So before your council advises you on that, we are in litigation on both of these parcels, and we have been for a number of years. We have not done any discovery as it was related to these cases. We've repeatedly asked for income information for these properties, and we've been repeatedly denied that information. Mr. Mann states that one of these properties would rent for more. Okay, more than what? It would be nice for us to have that information so that we could make a good decision. So we are able to get actually that information without the taxpayer providing it to us, but we cannot provide that information to you as a board because it is confidential and has not been provided to you. But I can tell you that we have put in there, we'll present in our package on the one in East Palatka, and both stores actually, but particularly the one in East Palatka, to show that the pro forma that we're using, that these stores are typically purchased on by using the income approach, are within guidelines according to what our assessment is.
Okay.
So, Mr. Chairman?
Yes.
The first petition, number 9, what store is that? Is that Interlaken?
I'm not sure. If it's assessed at $1,958,986, I get the petition numbers confused, but I believe you stated it was the Interlaken store,
Okay, it's $1,958,000.
which I believe is properly assessed.
Okay, so you don't have any objection to that assessment?
No, I wish it would be used for the
Oh, okay.
East Palatka. It showed for comparison as the property appraiser stated.
All right, all right. So, Mr. Mann, representing, are you an appraiser or, are you,
I'm a review appraiser.
okay.
I'm a real estate broker.
Uh-huh.
I've been representing people's property tax interests for many
And did
years.
you generate these figures yourself, or did Somebody,
Yes.
you did?
Yes.
Okay. So you think that the interlocking store is properly assessed?
Correct.
Okay. So the board can, and I'm not sure, what are you asking for in your petition on that store?
I'm asking for it to be assessed as you have it assessed.
Okay. So are you want to settle for that assessment?
That is fine, yes.
Okay.
I have
And
no
Mr. Property
problem with that
Appraiser,
assessment.
is your assessment okay with you?
Well, we actually believe that it's fairly conservative as far as our assessment goes. I mean, when you start looking at it a little bit more closely, we may have to address some items. We'll do that for next year, but certainly
is
we
okay.
feel like it's a conservative value at best.
Okay. Well, it sounds like you agree on that one, so that one's not an issue. You can, Mr. Mann, you could either withdraw it, or you could announce that you agree and you're willing to settle with the property appraiser.
Well, I want to keep the hearing active because, I mean, for you to
You
make
want
a
to talk about
decision.
it? Yeah.
Well, I don't think there's much more to say about it.
Okay.
Other than it just needs to go through the Value Adjustment Board.
All right, so
because
you
it's
want the board to
included
go
in
ahead
the
and-
lawsuit
All right.
with
So
both
he has no
properties.
objection to the assessment, so the petition should be denied. And the property appraiser's assessment should be upheld. And you can do that by a motion and a
Do
vote.
we have to hear from the property appraiser first, or can we just go on?
Do it.
Or, well,
Now that we've heard
some.
from the
I'm
petitioner.
sure he'd answer any questions you have, but I don't think there's an issue.
And this is on the one store.
That's
the
on
interlock.
9, that's on petition 9.
Petition 9.
Petition 9.
Nine.
Well, Mr. Chairman, I move that we deny this petition on the grounds that he agrees with the property appraiser's office that it's fair and accurate.
Okay.
Second.
There we go. Proper motion by Commissioner Turner, proper second by Mr. Gilliard. Okay. Any discussion? Okay, seeing none, all in favor indicate by saying aye.
Aye.
Opposed, same sign. Okay.
Good. Okay, now we can talk about petition 10, which is the East Palaca store.
Correct.
Okay.
Our prior testimony focused on that store as well. At this point, I have no more comments.
Okay.
Mr. Parker?
Mr. Hunt will present our presentation for you.
Good morning, Board. My name is Donald Hunt. I am the Commercial Manager for the Putnam County Property Appraiser's Office. I'd like to thank each of you for taking the time out of your busy schedule to form the Value Adjustment Board. We're going to go over petition number 10. If you could please turn to page number 2. On this page, I have a photo of the outside of the store and an aerial located on the bottom of the page. This CVS is located at the intersection of Highway 17 and State Road 207. Is there anybody who's not familiar with this CVS? Okay. If you can turn to page 3. This page reflects a building sketch of the CVS. And then let's go ahead and move over to page 4, which is the consideration of Florida Statute 193.011. So, according to the section 193.011 Florida statute, in arriving at just valuation as required under Statute 4, Article 7 of the Florida Constitution, the property appraiser shall take into consideration the following factors. 1, the present cash value of the property. The office reviews all sales transactions within Putnam County each year. Sales are analyzed in each subdivision and/or market area. A table containing comparable store sales is attached hereto. Number 2, the highest and best use of the property. The office applies a land code to the site and a Department of Revenue use code to the parcel, which takes into consideration the present use and the future use of the parcel. The office runs a report detailing all building permits that are pulled on each parcels, reviews of existing zoning ordinances and rezoning applications are made as indicated by the Department of Revenue Use Code. The highest and best use of the property as vacant is to develop the property with a commercial use consistent with the surrounding use and zoning restrictions. The highest and best use of the property as improved is a freestanding drugstore. The property is presently zoned C3 by Putnam County. Number 3, the location of the property. Each parcel of the property is assigned an area code or neighborhood code based on the location of the property. The subject is located at 238 South Highway 17, East Palatka, Putnam County. The subject is located in an area of high vehicular traffic and commercial development. Number 4, the quantity or size of the property. Land is coded by acre, front footage, or square footage. Improvements are coded by square footage of heated and cooled space. The subject property features 13,556 square feet of gross building area and is located on a corner and comprised of approximately 98,010 square feet of land, which is approximately 180 feet frontage along Highway 17 and 144 feet of frontage along State Road 207. The site is irregular in shape. Number 5, the cost of the property. This is developed by estimating the current cost to construct a reproduction or replacement of the improvements, adding the estimated land value and deducting the total estimated depreciation from the improvements. Building permit values are verified with the property owner when available and are contrasted with Marshall Valuation Service, a cost manual for developing replacement costs, depreciated value, and insurable values of commercial buildings and other improvements. And local contractors are spoken to. Number 6, the condition of the property. Physical inspections are performed on all properties in Putnam County on a 5-year cycle, when a building permit is finalized or when requested by property owners. The office requests all data related to the condition of the properties, such as sinkhole remediation reports, fire damage reports, and any other additional reports that may affect value. A site inspection was performed on January of 2011, September 13th, 2016, and September 21st, 2018, and an additional site visit was made on September 17th, 2019. The overall condition of the subject property appears to be in an average to good condition, as viewed by the appraiser. Number 7, the income from the property. The office analyzes income data provided by owners or representatives and compares actual income and expense statements to market-derived data to establish mass appraisal income modules, which are applied to like properties. As mentioned earlier by Mr. Parker, a copy of the lease agreement was requested for this property and has not been provided as of this writing. Number 8, the net proceeds of the sale of the property. The 8th criteria is considered in conjunction with the first criteria in determining the fair market value of the property. The reasonable fees and cost of purchase, along with any unconventional or atypical items of financing, have been considered from the perspective of both the buyer and seller, and any household furnishings or tangible personal properties have been excluded. The office regularly mails a sales verification letter in order to verify the sales price and to determine if any unusual circumstances exist. An example, family transfer or otherwise not arm's length transactions, tangible personal property included with the sale. Item number 8, the net proceeds of the sale of the property. The most recent sale of the subject property was recorded in Official Record Book 1309, page 1253, on December of 2011, recorded by a special warranty deed for $5,207,200. The second most recent sale of the subject property was in September of 2009, recorded under Official Records Books 1238, page 1445, and Book 1238, page 1448, for a combined purchase price of $1,250,000. If we can move on to page number 7, Summary of Salient Facts. The subject property is an operating CVS retail drugstore located at 238 South Highway 17 in an unincorporated area of East Palatka. The store contains approximately 13,556 square feet of leasable area and is situated on an irregular shaped tract of land containing 98,010 square feet of commercially zoned lot on the northwest corner of Highway 17 and State Road 207. The 2019 just market value, as noted on the trim notice, was $4,827,860. A request was made of the petitioner to supply all evidence to support their claim on September 12, 2019. A packet was received, and the packet contained limited information on all three approaches to value. After evaluation, we do not believe the information within adequately reflects the local market. Therefore, the property value remains at $4,827,860. As Mr. Parker stated, our office is currently in litigation with CVS for tax years 2016, 2017, and 2018. No discovery has occurred as of yet, and no depositions have been taken. We have continuously asked for income information on this property, as well as the Interlochen store, with no response to date. Florida Department of Revenue Guidelines, Establishment of Standards of Value. According to Section 195.032 Florida statute, quote, in furtherance of the requirements set out in Section 195.002, the Department of Revenue shall establish and promulgate standard measures of value not inconsistent with those standards provided by law, to be used by property appraisers in all counties, including taxing districts, to aid and assist them in arriving at assessments of all properties. The standard measure of value shall provide guidelines for the valuation of property and methods for property appraisers to employ in arriving at the just valuation of particular types of property, consistent with statutes 193.011 and 193.461. The standard measures of value shall assist the property appraiser in valuation of property and be deemed prima facie correct, but shall not be deemed to establish the just value of any property. However, the presumption of correctness accorded and an assessment made by a property appraiser shall not be impugned merely because the standard measures of value do not establish the just value of any property. The three approaches to value. The following techniques to value are utilized by this office in course of determining assessed value. The appraiser considers three approaches to estimating the market value of real property. These are the cost approach, sales comparison approach, and the income approach. On page 8, the cost approach indicates that an informed purchaser would pay no more than the cost of producing a substitute property with the same utility. This approach is particularly applicable when the improvements being appraised are relatively new and represent the highest and best use of the land, or when the property has unique or specialized improvements for which there is little or no sales data for comparable sales. The sales comparison approach assumes that an informed purchaser would pay no more for a property than the cost of acquiring another existing property with the same utility. This approach is especially appropriate when an active market provides sufficient, reliable data. The sales comparison approach is less reliable in an inactive market, or when estimating the value of properties for which no directly comparable sales data is available. The income approach reflects the market's perception of a relationship between a property's potential income and its market value. This approach converts the anticipated net income from ownership of a property into a value indication through capitalization, which is the rate of return on a real estate investment based on the income that the property is expected to generate. This approach is widely used in appraising income-producing properties such as this property. The cost approach. The cost approach for the subject was determined utilizing cost estimates from Marshall Valuation Services. We have considered normal physical depreciation only, since there is no functional or external obsolescence noted for the subject property. Please see pages 12 and 13 or the cost spreadsheet and extra features tab. The land value is based on actual cost of $1,250,000, calculating on the commercial base rate for Highway 17 of $620 per front foot. This rate was then applied for being on a corner location. The adjusted rate of approximately $12.04 per square foot was then applied to the total square feet of the subject land size of 98,010 square feet for a land value of $1,179,900. A refined replacement cost new was derived for the property of $131.33. This was multiplied by the gross building area of 13,556 square feet to arrive at a replacement cost new of $1,780,289. Less depreciation, 10% based on Marshall Valuation Services, equals $1,602,260. The extra features value of $1,605,260 combined with the land value of $1,179,990 were then added to arrive at an estimated value of $4,388,142. Therefore, the value conclusion by the cost approach is $4,388,142. Are there any questions on the cost spreadsheet and extra features? tab on page 12. This essentially goes through all the steps that I just read. Okay, so we'll turn to page number 9. We'll go through the sales comparison approach. The sales comparison approach contemplates the sales price of comparable properties and adjusts the sales for differences in the sale and the subject. Please see page 26 and 27 or the sales spreadsheet and sales map tab. There have been a total of 21 retail store sales within the last 5 years from date of appraisal in Putnam County and surrounding counties. The price per square foot of those range from $126 to $466 per square foot. The property appraiser has utilized retail properties that are similar in size and offer similar utility as the subject. Currently within Putnam County, Dollar General, Family Dollar type stores are the primary type being traded on the open market and have been utilized as comparable sales. In addition, an additional search for sales of CVS Walgreens was conducted within similar markets as the subject, resulting in a total of 11 additional sales, which range in value from $203 to $466 per square foot. In addition, this parcel sold in December of 2011 for $384.13 per square foot, or $5,207,200. A per square foot price of $352 has been determined, or 13,556 total square feet by 352 is 4,771,712. Value conclusion by sales comparison approach is 4,771,712. Does anyone have any questions on page number 26 for the comps that were used?
I just think I'm a speed reader.
Oh, I'll go slower. I apologize. On page number 9, income approach. An income and expense questionnaire was mailed to the property owner in early 2013, requesting data for the year ending December 31st, 2012. Be provided to the property appraiser no later than May 1st, 2013, and every year since. As mentioned earlier, a copy of the lease agreement was requested for this property and has not been provided as of this writing. If you turn to pages 28 through 31, the income approach tab. By utilizing the 2011 sales price and historical cap rates, along with market studies of similar CVS Walgreens retail pharmacies, an estimation of net operating income was derived. This approach is widely used in appraising income-producing properties, such as this property, which are typically purchased for their income-producing capabilities. Therefore, this estimate has then applied. The estimate was then applied to current cap rates, and a value was arrived at $4,829,235. The value conclusion by the income approach is $4,829,325. Are there, looking at the income approach tab, are there any questions on how we arrived at the value?
No questions?
Okay. So we'll turn to page number 10, conclusion. Putnam County Property Appraiser has properly followed the appraisal guidelines established by the Florida Department of Revenue in arriving at the just value for the subject property. Number 2, the property appraiser has properly considered all 8 factors as required by Florida Statute 193:11. Number 3, the property appraiser has followed professionally accepted appraisal practices, including mass appraisal standards when appropriate. Number 4, the property appraiser has established the presumption of correctness by complying with all applicable Florida statutes, guidelines, and accepted appraisal practices. Following is a summation of the 3 approaches to value in support of the 2019 assessment. Cost, $4,388,142. Sales comparison, $4,771,712. Income, $4,829,325. For the above stated reason, the property appraiser respectfully requests the 2019 just value of the subject property be upheld at $4,827,860.
Okay. All right. Any questions from the board?
Mr. Chairman, go ahead.
Okay.
I was just concerned, you may not be able to answer this one, but why have they not given you the information that you requested? Is,
I'll let Mr. Parker answer that.
Sure. Well, the tax representative is not the corporation, correct? So he's just representing them, and they hold that information very close to their vest. Because if it were brought out in a hearing like this, it would become public record. So they don't want that information to be public record. They want to withhold that information. So we have recently asked the courts to expedite our case or dismiss it, one of the two, because we've been doing this for about 4 years now. We're not pushing it, okay? We're relying on the taxpayer to actually push it, but typically, but now we're at the point where it's just been hanging around, and so we want to address the issues. And in that litigation, a lease will be provided. I mean, obviously, that's up to a judge to say whether a lease will be provided, but I cannot foresee any reasonable reason why they would not order the client to deliver that. So the tax representative is at the mercy of his client to provide that information to us, and they have chosen to direct him not to do that, or maybe have not even given him that information so that he could provide it.
and so I saw in as we were going through it, 2016, 17, 18, and it's already in the system.
Yes.
So am I right to assume that we haven't gotten anything from them as far as paying their taxes? They're part of what?
They'll go ahead and pay their taxes because there's some certain rules as it relates to filing lawsuits and paying their taxes. So I believe the taxes have been paid on this particular property based on our current assessments or our assessments for those prior years. You do have the ability to pay a good faith payment based on what you believe the taxes to be, but I don't believe that they have made payments, a good faith payment on anything less than what our assessed value is. Are you?
Mr. Turner?
Yes, on your conclusion page, on page 10, your cost analysis is of $4,388,142, and the sales comparison is more and the income is more. How come you took $4,827,860 instead of an average of the three, or picked one of them, or whatever? I mean, you may have said that, but it got by me.
Sure, because of the income producing capabilities of the property, we're using the income approach as our main approach to value for this.
And
So
by
you-
that, oh, excuse me.
Oh, sorry. So why wouldn't you take
The full value.
an appraisal of average of the three or something? I mean, you got three appraised values and they had state different amounts. Why wouldn't we? I mean, I'm not trying to be combative. I'm doing this for my
Sure,
own,
sure.
for my own knowledge. Why would we not take an average of the three?
Well, through the reconciliation process, we do look at all three of them. However, at this point, we did feel that the income was the most probable outcome for this.
Gotcha.
And so when you say that I guess you're looking at the surrounding properties and areas and the rate at which the location of this store and the surrounding is growing with the addition of the Taco Bell and the
That's correct.
Popeyes and those things. So you took that into consideration, that traffic
Yes.
may even increase
The
to
traffic
7
count,
and-
I have looked into the traffic count for this particular store. It's at 32,500. For some of the comps that are actually around $459 per square feet, they're at about 22,000 cars per day. So this, on a traffic count basis, that's why we're sort of at the higher end on the sales comparison approach. So we are taking into consideration the growth of the area.
Okay, and he mentioned the wall.
The
Talk
wall,
to me
yes.
about the wall.
So essentially what happened on this piece of property is when it was originally constructed, there was a stream that actually ran up under the property. So there was a lot of development cost in bringing the ground grade up. As you drive by it, which y'all are all familiar with the property, there's a pretty thick retaining catch basin along the side of the roadway. And then, of course, I believe about 3/4 of the property is surrounded by this wall. And I believe the water is still running up under the site and so forth, using our aerials that we have on this.
Mr. Newfound?
On page 6,
Okay.
you said that the most recent sale was in December of 2011 for $5.2 million.
Yes, sir.
And do you know who that was sold from and to? Was it a different corporation?
You know, I don't have that directly in front of me. Mr. Parker, would you, by chance?
You can look it up.
We'd have to look that up, yeah. We did qualify the sale, so it was an arm's length transaction, meaning that it was not from family member to family member or parties of similar nature.
So it would represent market value at that time?
Mr. Chairman?
Mr. Dixon?
Back to something, Mr. Turner, it says you have these 3 estimates, and yet your just value is none of those estimates.
It's closest to
It's
the income
close.
approach.
I'm just curious about why you don't choose an actual estimate. Is there a reason that it's, I mean, it's a almost insignificant amount of money here in this case. Why is there a reduction? What's the methodology that determines that?
Well, we appraise properties en masse. So we do revisit the property yearly, and essentially, we did look at the income approach on this one. So we chose to go with that particular approach after we looked at all the values.
It still just gets close to what you estimated, not the actual figure that you estimated.
Right, just due to the system, well, not to the system, it's the way we have to put it in based off of the cost approach in the computer.
Okay, so I guess I can ask a question, may not answer it, but anyway, so back, if we refer to the interlocking store, you have the same 3 comparisons there, but you chose to go for I guess the cost one. I was just wondering why that one versus this one here, because it is at the low end, it's not much. It's, you know, it's only $500,000 difference from the high end. I was just wondering why you chose the cost on that one versus the income on the East Palaca one.
Yes. With the recent sale of the East Palaca sale at $5,207,000, we felt that we should have went with a higher value on that one. The store in Interlochen has not sold recently, so we went conservatively on that store.
So that's an internal decision that you're making at the appraiser's office?
Yes, sir. Yes, sir.
So do you feel that this is conservative on the East Palaca store?
Mr. Parker?
I'm sorry, if you want the answer to Ms. Gilliard's question, or, I'm sorry, who asked the question as far as the grantor grantee on the properties? So the
Joan
property sold on December 1st, 2011, between CVS 3519 Florida LLC to AIN 11 FL East Palaca LLC.
Thank you.
So the building actually that we're talking about sold for $5.6 million, is that?
5.2.
Okay. And the plaintiff is concerned that we're charging them for 1.8 in taxes, but the building sold for 5.2?
The value, it's sold for 5.2, we're assessing them at 4.8.
I wondered that that include the stock inside the store too.
No. At least if it did, I mean, you're not supposed to pay dock stamps on the stock inside the store. So typically, CVS will build these stores, they'll find an investor, and then they will lease that property back from the investor. So they guarantee the investor a certain rate of return on their investment. And we've determined that rate of return to be around 6%.
Yes, sir.
And in that regard, we're actually a little bit conservative on the rate of return. So the lower your rate of return, the higher value it's going to produce. So we use 6%. I think the petitioner used 6.25%, and I think there is some evidence out there that we could have used 5.75 and actually generated a little bit higher number. So if we did use the 5.75 and generate a higher number, then that number, that income number, would have been a little bit higher than what the current one that we're actually using. So we were fairly conservative in the rate that we chose to use. So then you would see a bigger difference between the income and our assessment. So our assessment, when we do it in our system, we have to reconcile all three approaches to value, cost, market, and income, to produce something that we can show you on a piece of paper so that you can look at it, so a taxpayer can look at it. So some of the factors that we have to actually use within the limitations of our computer-assisted mass appraisal system, we then have to, in some sense of the word, back into our computer system the actual numbers that we're actually looking for. I mean, I think most fee appraisers, when they would go out to a property, kind of like the petitioner said, it's worth $2.5 million. They just kind of round it off. You know, if we were going to round something, I would probably have rounded it to 5 million. Okay, could we make our system say 5 million? We have the capability of overriding our system and just saying $5 million. And then this is how we got there. We looked at the income, we looked at the market, we looked at the cost of the property, and we came up with this number. So we're trying to give you the number that the taxpayer is actually seeing, but there's a lot of processes that goes into coming up with the actual number that we assess it at.
Okay, any other questions? All right.
Mr. Chairman,
Okay. Yeah, what's the pleasure of the board?
I move that the admitted evidence proves by a preponderance of the evidence that the methodology used by the property appraiser to assess the property compiled with the statutory requirements and professionally accepted appraisal practices, and the appraisal is entitled to a presumption of correctness.
I second that.
Got a proper motion by Commissioner Turner, proper second by Mr. Dixon. Okay,
Yeah, I think you need a motion to deny the petition and uphold.
Okay, and therefore I deny the petition.
That's a motion. Move to deny.
Well, along with my other statement,
Let's have a
I
motion.
move to deny.
There you go.
Okay.
Second.
have you got a second? Okay, so we just have vote once?
Yeah, vote again.
Okay. All right, all in favor indicate by saying aye.
Aye.
Opposed, same sign.
We can work on that.
Okay. Okay, so we're good? Okay. I think that's all we have on our agenda. Okay. I want to thank the board members for their participation, Mr. Bedslow for your legal counsel, and Mr. Parker for all the information. And if there's no further business, we stand adjourned.
And we just leave this here.